They put that stuff in a really high temperature.
Hello and welcome to our neck of the woods. I'm going to be reading again today from the Paper Arrows PDF that we were reading yesterday. I'm going to reread the last paragraph and then start anew. Let me pull that up for you guys. So give me one moment here. Also, I came across, I hope that some of you have, hi Anna. I hope that some of you have decided to look at that PDF yourselves and read through it. If not, no worries. I'm going to keep reading. I'm going to reread the last paragraph that I read yesterday before I go forward. So give me one moment here. Let me get everything situated. Make sure you guys can see what's what. Actually, I'm just going to do that. You don't need to see me to hear me. Can you guys hear me? Make sure that you can hear me before we go on. I hope Little Sage is doing okay, Anna. Hey, Lucy, how you doing? Can you guys hear me then? Okay, wonderful, wonderful. Hey, DT, good to see you. All right, guys, I'm going to go ahead and jump right into this and get started. I'm not waiting around for folks today. So, because I want to get this information out to you. There's so much more information coming. Okay, hey, big brother. All right, here we go. We are on page 22 of the PDF. If you did go ahead and download it and you want to follow along, that's wonderful. You know, I will be putting my own commentary in there in certain areas. Okay, so we are about 2/3 of the way down through page 22 of Paper Arrows by Harold Griswold. America can only be free again if the corporation known as the United States were abolished. I did not expect to get much help in that effort until they picked a new wizard over there in Oz. The new Wizard of Oz, Billy Clinton, is running American corporations out of the country at a record rates. He is running the biggest portion of his own government taxes based out of the country. That is revenue to support the United States of America Incorporated. He has done more in a few months to destroy the United States than all the rest of the anti-government movement has done in the last 50 years. He may very well destroy about 98% of the corporation called the United States in his first term alone. There may be some chaotic times ahead as this happens and becomes apparent. There will be more police control to prevent the fall, but it looks inevitable. Property will be confiscated with a fight if necessary. There are reports that United Nations troops are being trained at the abandoned military bases around the country to help with the control of the people when all property is taken for payment of the debt to the World Bank and the International Monetary Fund and the Bank of England. There are reports of troops all over the country and on each border, Mexico and Canada. Something seems to be in the making here. Now I'm going to interject something here. This book, Paper Arrows, was written in the time of Bill Clinton, and yet we see remarkable comparisons to today. And I want you guys to keep that in mind. This paper was written a long while ago, but yet the plan is still in progress all the time. All the time, their plan is still in progress. Okay? The money system is about to collapse, and the American people are striving and struggling to keep it from collapsing. The people do not realize that this system is bad for them, and that if they would quit struggling so hard to support it, we could get away from it sooner. The people in the government are trying to make it collapse, but we will not let it. They will win over one day, and we will all be issued new money, and our property will be placed in the hands of the holders entirely. But if we keep struggling for what we think is ours, they will have to bring in the troops and make us quit struggling and then keep the peace in America with numerous troops in the streets. Sound familiar, guys? The people that inhabit this country, America, may not wake up until it hits them where it hurts. Their cars. Yes, their cars. You can do anything to the American people, even charge over 20% interest on borrowing to pay for luxuries and necessities alike. You can take their kids away in buses to public brain laundries. You can even make them pay taxes and insurance that amount to over 80% of their pay. But do not fool with their cars. When that happens, look out. And see, this has already happened. We all know this has already happened. The other thing to look out for is the day that all the pensions are cut off. The government is hoping that before anything big happens, that the majority of World War II and Korean veterans will be dead and gone so that they will not have to face them and their dependents. But there are other types of pension holders, and they will be just as mad, but they may not have proven battle records and may not know how to fight in a hand-to-hand combat. But a little lady with a big iron skillet is still a force to be faced, and there may be millions of them too. The Rodney King incident shows that justice system in the United States should be spelled just us. It is just for them, the police and others in the government at all levels. Those officers should all be in jail for the treatment of anyone in the manner that they treated Rodney King. The scum that beat him up should answer for it, but that is their law and is made for them. The Holocaust at Waco proved that when they murder innocent Americans there and nobody stopped them, who will stop them in other towns around America the next time? Who stopped them at Randy Weaver's place? What about Gordon Call? He was burned also. But the government wants us to think that they are taking care of us. The government even created a Department of Human Resources, which is where your mother placed your body at birth. Yes, your body into the government vault. You were identified by your name on the paper. If you were missed there, they set up a socialist security system for you to sign your own self into their vault at the Social Security Administration building. Now you are property of the government. Babylon has taken away the children. They control the bodies of the children and everyone else that fills out the forms for the government. Babylon has taken all property or stores, as the Bible refers to them. It has been accomplished through paper documents known as instruments. For those that want out of the jurisdiction of the United States, the law has been provided for anyone to be able to expatriate when they reach the age of 18. Look it up in the Corpus Juris Secundum under citizen. All right? The deed to your land is not in your hands. It is filed in public records in the court. The government has it. The government is the holder in due course. You just do the maintenance of it and keep the value up. You manage it for the bank or the government if the bank is paid off. The title to your car is not in your hands. It is filed with the state, and they allowed you to register it while they hold the original title, not the certificate of title that you have in your top drawer at home. Certificate of title and the true original title are two very different pieces of paper. Which one do you have? Do you have your car? Most people do not. The state does because they hold the true title. Look at it and see for yourself. The manufacturer's statement of origin, or the MSO, is the actual bill of sale and title. The dealer gives the MSO to the bank or the government when you buy the car. Ask him about it. The Constitution is alive and well and does not need any help from the patriotic groups around that want to restore the Constitution or help preserve the Constitution or repair the Constitution. None of these things can be accomplished and do not need to be. The government is living under it very well and prospering at our expense. It is very healthy as far as they are concerned, and since it was written for them, by them, it is doing very well. In Article 2, the Congress had the power from the very beginning to create uniform bankruptcy laws. What a setup. What are we living under today? We are living under bankruptcy. The framers put that there so that the situation of bankruptcy could exist and put all law under uniform bankruptcy laws and the bankruptcy court in order to control and monopolize every aspect of business in America. That has happened. The one court that cannot be overruled in the United States is the bankruptcy court. Its decisions are superior to all other courts. It cannot be overruled. That makes it the Supreme Court in the United States. You guys getting this? The Supreme Court is actually run on bankruptcy court laws. The framers of the Constitution were not these nice little old men that had our best interest at heart. They were a bunch of schemers with a flair for intrigue and cabal that surrounded their every meeting and was included in every document written by that bunch of ring twirlers. There may have been a couple of good people that got involved. They were not all bad. Without the good men involved, the grand scheme would have been accomplished much sooner. But do not refer to them all as founding fathers and suggest good intentions on all of their parts. Andrew Jackson was one of the good guys that came along, and in the 1830s, he threw out the bankers and abolished the national bank. By doing that, he delayed the country's falling into the bankruptcy for another 100 years. He was a good, decent man that got into the presidency and threw the money changers out. Years later, they tried again to put this country into debt and eventual bankruptcy with the Civil War. Abraham Lincoln saw what the bankers had planned and stopped them at every turn. He even issued the greenbacks to take the debt out of the hands of the lenders. He would not agree to setting up their national bank and borrowing their worthless paper money at 20% interest and putting the United States into huge debt quickly at that rate. So he threw them out, and they sent one of their hitmen over there, and Lincoln was murdered. John Wilkes Booth was an employee of the Rothschilds Bank of England. It was the banking house that Lincoln had refused. Lincoln did not set up a central banking system in America and delayed the takeover again. The war amendments had not been ratified by the proper number of states, while Congress was in session, and in attempts to gain control of this country through fraud continued. Andrew Jackson attempted to stop them, but only succeeded in slowing them a few more years. The fight had been going on for a long time, and finally the bankers came up with a fraudulent scheme to trick the public and politicians into agreeing with the debt system and bankruptcy. They set up the Federal Reserve, which is not federal and has no reserves. This is the central banking system that they had been trying to establish since before the formation of the Republic. This was a central banking system that could not be called that out in the open. Everyone who immigrated from Europe knew that the central banks there were the cause of high taxes and debt burdens. The people would have revolted before setting up a central bank here, so it was called the Federal Reserve Banking System to conceal its true identity and sell the idea to the people. Color in legal terms means not real. Color of law means that it is not real law. Anything that is not real and is held out to be real involves fraud. The 13th, 14th, and 15th Amendments were colorable since they had not been properly ratified in the 1860s. The 16th and 17th Amendments were never properly ratified, with no quorum present in Congress in 1915. And if you look back at the ratification of the Constitution, that whole process was also colorable and makes the instrument a fraud. There is fraud everywhere. If the passage of these ideas and documents had to be done by using fraud and trickery, there must be something wrong with all of the laws that were just mentioned, including the Constitution. There is no law in this country anymore. The Law Dictionary defines anarchy as the absence of law. The Law Dictionary defines the color of law as being that which has the appearance of law, but is not real law at all. If it is not real law, then it is the absence of law. We do not have a democracy. We have an anarchy now. Over the years, I have slowly come to believe that citizenship is not a good thing. And I have told you that civil rights applied to citizens. Civil means emanating from civil governments. So civil rights would come from civil governments. If the government gives you something, it can always take it away, and you should not want to accept these rights from the government and do business with them if you had the rights in the first place. I thought that it was not a good idea to use these civil rights laws to try and fight them. So I looked at every other possible means that I could find, such as common law complaints, civil complaints, and civil and criminal procedures. I even used these foolish constitutional rights claims, common law rights claims, and substantive and God-given laws and rights claims, and none of it worked in the courts. A couple of times I got close to, and the judge would say it was not quite right. I said the right thing, but I did not say it the right way. But they would not tell me what was wrong with my case. The answer to the problem I was having turned out to be in the very thing that caused the problem in the first place. The answer was in the 13th and 14th Amendments, civil rights legislation. Under civil rights legislation, the government has waived all immunity. They are not immune to any civil rights claim whatsoever that is made. They have removed all legal requirements of the rules of court that apply to all lawyers in the courtroom or any court action. There is no basic format that has to be followed. They have waived the Anti-Tort Claim Act pertaining to tort claims under civil rights legislation. A standard tort claim that cannot be made against the government is protected by the Anti-Tort Claims Act, but a civil rights tort claim rolls right straight through. They are not immune. I'm going to read that last sentence again for you guys. A civil rights tort claim rolls right straight through. They are not immune. The remedies were put there, all that was necessary for us to learn to utilize them. But I still had the feeling that as a citizen, you should be entitled to this, and if you were not a citizen, you should not be entitled to any of this protection. I received a copy of a court case called Otherson versus U.S. This was where two Mexicans came across the border and were beaten up by a couple of border guards. These Mexicans got a lawyer, and he put together a good civil rights suit. This lawyer found out that civil rights legislation was intended by Congress to cover everyone who came within the jurisdiction of the United States, no matter who they are. He figured out that by the wording of the statute itself, it states, anyone who causes a deprivation of the right of a citizen of the United States or other person is liable under the law. The or other person is what extended it beyond the citizens of the United States. That is Title 42, Section 1983. I read that back in 1983 or along about then, and I never picked up on the other person part. So what he's letting you know right here is that even if you're sovereign and out of the government and no longer an agent or slave of the government, you have that other person if you need to take something to court. Okay? The most serious errors we have made is thinking the courts have been established by Congress or the state legislatures, and that established jurisdictions are set up by these legislatures to the extent that the courts can hear cases and that the legislatures can tell the courts what kind of issues the courts can hear. At no place at all, anywhere, in any of the laws of the state legislatures or under Congress, has the court ever been given the power to hear any political or religious issues. The courts are not there to hear anything about the Bible or God, so do not bring either of them in. The 16th Amendment was not properly ratified, but that is a political issue, and the court cannot hear a case based on that. When the fact that the 16th Amendment was not properly ratified was brought up as a defense, the judge said, "Talk to your politicians about that issue." Political issues cannot be used as a defense and cannot be brought up in court, period. These political issues are irrelevant to the court, but they are proof of the fraud. But since they are not defensive, you cannot bring them up. If the government wanted to bring a case against a government agent, it would then be a criminal charge against him because he did not get the license he was required to get. The fact that he is doing business with you and he does not have a license is not a defense for you of why you did not pay the debt that you owe him. It is irrelevant to the case. It is a political issue because only politics can control his operation by regulations under the license and force him to have it or let him go on without it. It is not relevant to your case. American jurisprudence is abbreviated AmJur. It is an encyclopedia of law like the Corpus Juris. In Book 16, Constitutional Section 2D, under Constitutional Law, in Section 394, it gives a 4-page explanation of why Congress has never given power to the courts to hear political issues. It gives the established rule in the beginning to be beneficial to them, but if you use it the right way, it can be beneficial to you. It states, the government has never given any jurisdiction. I'm sorry, let me start that over. It states, the government has never given jurisdiction to the courts in any way to entertain any kind of argument under the concept of a Republican form of government, which would relate to a political issue of how the Republican form of government was operated. It says clearly you cannot. It goes on. But it has pointed out that even though the plaintiff in an action in a federal court for a violation of their constitutional rights might conceivably have added a claim under the provisions of the federal Constitution that the United States shall guarantee to each state a Republican form of government, and such a claim, because non-adjudicable in political nature, could not have succeeded. The plaintiff may be heard anyway on their claim of a violation of Equal Protection Clause of the 14th Amendment, provided that the claim is not so immersed in those political question elements that it would render the claim under the Guarantee Clause non-adjudicable. That means if you word it the right way, guys, it doesn't become a political element as much as it becomes a claim. And there is a difference. This is why I talk about how they use language to mess with us all the time. And it is very prevalent in our legal systems everywhere, okay? It looks like a fine line there. You cannot bring up such subjects as the 16th Amendment not having been ratified. That is blatantly and clearly set forth. It is a political question. There is a way to get around this using their fine line of a remedy available. If we say the functions of the agents of government under the pretense of approved law of the 16th Amendment may have caused a deprivation of your rights by their actions, then we do not have a political question, but we've still brought the same issue in the 16th Amendment. If you twist the wording around the right way, it will work because we said that the agent acting under the color of law, remember, color means, that it's not real. It's the appearance of being real. So if you're acting under the color of law under the 6th Amendment, caused the deprivation to your rights and violated the Equal Protection Clause of the 14th Amendment, now you can set a claim in the court. But understand that we cannot set the claim in court that the government agent did not have the right to do what he did because the 16th Amendment was never ratified. That turns it back into a political question, and it cannot be answered by the court. The attempt to use political issues such as the lack of ratification of the 16th Amendment or the non-registering of foreign agents will result in the court throwing out the case by saying that there is a failure to state a claim upon which relief can be granted or that the motions are meritless. We have heard many times from the judge that there was a failure to state a claim, or the motion is without merit, or that there was a failure to state an objection. And you guys, Again, this is modern day. This is everything going on with the selection process that happened, and all those cases that got taken to court were thrown out as meritless. It's not that they didn't have merit; it's that they didn't speak the right language. The reason we failed in using these issues was that we were trying to say that they did not do their jobs correctly. Well, so what? What does that have to do with the fact that someone said a tax was owed? It is not even relevant to the issue. The court rules state that the motion, the complaint, and the answer to the complaint must be concise and direct. Most cases are loaded with political hogwash, such as, I do not agree with the debt of the United States, or I object to the government putting us in debt. The court does not care about that. It is a political issue. We have been wording this stuff entirely the wrong way. All of the patriot knowledge that we have been getting is fabulous information to get our minds set to the point that we understand what the government is our enemy, but none of it is usable in court. That is why we've been losing all the cases. We have now won a case after 14 years of trying. A man in Michigan was attacked by the IRS with both civil and criminal charges at the same time. The attack started about 3.5 years ago. Within 6 months' time, they got a conviction on him and sentenced him to jail for 2 years. He spent 2 years in federal prison. About a year ago, he got out. His name is Dan. While he was in prison, they followed up with the rest of the civil attack. The IRS put his home up for sale. It is a 50-acre piece of land in central Michigan with a house, barn, septic tank, and all the necessities, etc. It's worth a lot of money. They sold it for $13,600. That is how much they claimed he owed them. For just that small amount of money, they put Dan in jail for 2 years. Those people have no compassion. For a nickel, they might kill you. They auctioned off Dan's house. Someone had a copy of a common law lien that I had done on my house, and they showed it to some friends of Dan. They got in touch with me and managed to get the common law lien on Dan's property drawn up with some study and research on their part. They called Dan and asked if they could sign his name to it, and he agreed. They went to court and got it filed after some stumbling around a bit. Now, there was a $190,000 lien, so we gave notice to the man who paid the auction price by calling him to see if he was aware that the lien existed. He may have been told to buy the property anyway by the IRS and that the lien did not matter. He never said as much over the phone. A few months went by, and Dan called me to let me know he was trying the suit. Dan asked me how. I told him to remember the papers that I gave him on counter complaint. According to Rule 12 of the Rules of Procedure, both civil and criminal, the only way to answer a case is by counter complaint. If you fail to counter complain, you fail to responsibly answer the claim. Even the legal profession does not know this. The lawyers do not understand this. It is clear as a bell in Rule 12. But you cannot understand Rule 12 until you understand the Uniform Commercial Code, the UCC, right? From which all rules of court are patterned because the courts are conducting business and trade in the United States, in the corporation. You guys got that? The UCC is available online. Just like the Law of War Manual, the UCC is available online. All you got to do is put in UCC or the Uniform Commercial Code, and you will bring it up. You will have all the information at the tips of your fingers. Remember, America is a business, right? That's why 45 did such a great job, because he's a good businessman. He ran the business. See? Ins and outs, guys, ins and outs. Dan wanted to know what to use as the basis of the complaint. I told him that we all know what a fraud this whole government scam is and how it operates, and how to go into the statute of frauds in the UCC and see if any of it applies here. The statute of frauds says that any transaction involving $5,000 or more as the value of property must have a signed agreement of contract to sell. Otherwise, the taking of that property would constitute fraud. That must mean, on the other side of the coin, that anything under $5,000 must be a permissible fraud. Evidently, the law permits fraud up to $5,000, but does not permit fraud above that amount. That sounds crazy, but that is what it appears to say. Go look it up. And on this note, before I go further, I'm going to say this. The difference between theft and grand theft in their charges, when they charge people with those crimes, is $5,000 mark. Believe it or not. And that goes straight back to those uniform commercial codes, you guys. So $13,600 on this claim deed that Mr. Sapp supposedly paid is more than $5,000 and would come under the statute of frauds. Dan should do the counterclaim that Mr. Gapp got the deed by fraud because Dan had never signed a deed to sell the property. Because the IRS perpetrated such a fraud and Mr. Sapp is a party to the fraud, he becomes a co-conspirator in the fraud. The lawyer for Mr. Sapp answered and said that the issue we brought up would have to be faced in a federal court. The lawyer said that they did not disagree that Mr. Sapp acquired the deed on a certain date. It was a fact that he did acquire the deed. We said that the deed that he did acquire that day was a fraud and that Mr. Sapp had no right to the property in which he acquired the deed by fraud. So that is a counter complaint, a complaint that Mr. Sapp would not have a right to this property if it were not for a fraud that he and another that he conspired with perpetrated upon Dan, the owner. Dan shot this into court, and Mr. Sapp's lawyer responded by saying that Dan did not deny that Mr. Sapp had the deed, so the lawyer moved for a summary judgment. So we wrote a motion to quash the summary judgment. The motion to quash is a continuing sort of counter complaint that says we object to the summary judgment but do not care what you do. Now, if the summary judgment is granted, the court becomes another co-conspirator in the perpetrated fraud and involves itself in the federal case that we are bringing against the IRS and all of the co-conspirators in this action. The judge recused himself, and they cannot find a judge to take the case. What a way to win. The court did not want to become involved in the fraud. If you do not bring up the issue of fraud, the court will let fraud continue. Fraud is allowed until you bring it up. You must bring it up. They cannot. The court can go by only what is told. The IRS and the courts have seized and sold property in the past, and the owners argued all the constitutional rights and the common law rights to this issue and that issue, and how their Bill of Rights did this and that. It was all nonsense, and it was not relevant, and the judges threw the cases out of court. The arguments were dismissed, and the judges ruled in favor of the ones who had the deeds. Under the summary disposition rules, if an instrument is brought in as evidence in the case, remember, an instrument is a document, it is presumed by the court that the instrument is good on its face. Now, it is up to you to show that the instrument is not good on its face. If you do not do that, then you have failed to responsibly answer by counter-complaining their presumed legitimate complaint that they have the right based on the documents being good on its face. Dan wrote it up with a little help. He called the other day to tell me that he went to court on March 2nd, 1993 for the hearing on the summary disposition. When he got there, they told him that the hearing was canceled. He said he did not believe them. So Dan went to the court clerk's office, and the clerk said that the hearing was canceled. Dan said, "I am here Why has it been canceled? The clerk said, the judge is not here. Dan asked, why is the judge not here? The clerk said he recused himself. He does not want anything to do with this case. So Dan asked when there would be another judge to take the case, and she replied, I do not know if we will ever get another judge to take this case. If you build a box and put them in it, they cannot get out. The system and its own actors have built all of the sides of the box. All we need to do is learn how to put the lid on it and nail it shut. We will have them trapped in their own scheme. They cannot deny these frauds because we can prove them. And there is no statute of limitation on fraud. We can take it back to the beginning if necessary. The statute of frauds is in the UCC, the Uniform Commercial Code, in Section 2-103 or Section 2-203. Look it up. An instrument is a written document of any kind, a lease, bond, will, or title, etc. Remember this definition. It gets used in the UCC all the time. An instrument is a written document of any kind. You guys, I'm going to take a break before we go in here any further. And I'll look at chat here. Oh. RTD. I'm sorry about the R2D2. Are you guys hearing me now? Hey, Pappy. Hey, Pugs. Okay, guys. All right. Sounds good. Well, let me get a drink here. And any questions on this section of the book so far? I found Jeff came across another one in the SPC University downloads. That link is also in the description box. You guys, I want you to check it out. Check out the paper. I think it's under Gurus as well, right? Under the Gurus section, called The Matrix and You. It is written by a judge, and it will blow your mind. And it was written in 2009 in the time of Obama. All right, Pugs, have a good day. All right. So, am I boring you guys reading this stuff? I feel like it's really important information to share with you. So, all right, right back to it. So, we read instrument. Huh? No. Signature. Under liability of parties, Section 3-401 of the UCC, signature is the name of that particular section and says that no person is liable for an instrument unless his signature appears thereon. Okay? Contract. An instrument is a written contract of any kind. An application for a mortgage is a written document and is an instrument. It is also a contract, and your signature appears thereon. You have to sign it when you make the application. An application for Social Security is a contractual form of an instrument with your signature on it. Now you are liable for anything connected to Social Security, like contribution. Contribution means the forced exaction of money from any party who participates in the scheme to ensure the debts and losses of all the other parties who are party to the scheme. The insurer of Social Security is you. That is what the definition says. Social Security was sold to the American people as being a good Christian thing to do. We all wanted to take care of the elderly. That is the way Social Security was sold to America. It must be a good thing. But Social Security is not the name of the law implementing Social Security. The name of the law is the Federal Insurance Contributions Act, or FICA, is what we see written on our paycheck withholding each payday. If it is such a great idea, they should call it what it is and not what they tell us it is. If we will look up each of the words in the title of the law, we will find out what it is rather than what the government tells us it is. Now you know what the initials mean and what contribution means. It is probably not what you thought it meant. This means that the agency can take any amount of money that they need to offset the debts and losses of the rest of the parties to the scheme. And by the way, they can dip their hands in that Social Security fund and just keep stealing out of it. It's set up that way on purpose. Since the United States government is the largest party to the scheme, you must be responsible for the debts and liabilities of the U.S. government. And they have run up a tremendous debt. And your signature on the application made you liable for the debt that the government created. We, you and I, owe the national debt because we guaranteed it for them. They can spend all that they want. The American people will pay the bill, the ones that are in the Social Security program. Our signatures made us liable. We do it if we signed for it. It says that no person is liable unless his signature appears thereon. Why did they not say that if your signature is on the instrument, you will assume the liability? That is what it means. No person is liable unless his signature is on there. Was written to mean that when his signature is on there, he is liable. Here is how his liability is established to the law. Unless the instrument clearly indicates that the signature was made in some other capacity, it is an endorsement. An endorsement is a full acceptance of everything associated with the agreement that you are making. Endorsement, as defined by Black's Law Dictionary 5th edition under accommodation endorsement, in the law of negotiable instruments, one made by a third person without any consideration, but merely for the benefit of the holder of the instrument, or to enable the maker to obtain money or credit on it. This means that an endorsement is an accommodation, which accommodates the person who made the instrument you endorse. When you endorse application for registration of an automobile and you give them the paper that you signed called the application for registration, you have endorsed the instrument, left the instrument in their hands, and enables them, the maker, to borrow money or credit against it. That is how the government got to spend so much money. They got credit because they put your property up as collateral. In the case of Social Security, your body itself was the property that was put up as collateral. When you signed the application for an automobile registration, your car was identified as the property to be put up as collateral for the government to borrow against. When your lawyer signed the transfer affidavit at the public records of the court showing the transfer of the deed to your house from someone else to you and filed it in their records, then he endorsed that for you, acting as your agent. They used your house as collateral. It was the property named on the instrument. When you, dear mom, put your endorsement signature on the bottom of an application for a birth certificate for your child, you turned the body of the child over as property for them to borrow money against. The child was named on the instrument. The Office of Human Resources of the federal and state governments deal with human beings as resources. The humans are treated as resources just like oil, timber, minerals, or agriculture, etc. Human beings are property to them and treated as such. When you sign the Social Security application, your body is identified as the property. I had the chance to upset some poor guy in Baltimore. I sent him a bill for something which I will read later. He called me about this matter and he asked me what this was all about. I told him that he deprived me of some of my property rights by his actions and I was billing him for the loss. He said he knew that, but told me that I made a threat down here that I would do a distraint warrant and execute against all property he had. I had listed the property and told him that I would take his house, his car, his wife, his children, and any tools he had. He got upset about the wife and children. He said that taking them would be slavery. He said, "You cannot do that." I told him that he did not seem to understand that they were already slaves because they were property of the government. I told him that right then he was the holder. But he had a debt to me, and if I can collect on this debt, then I can become the holder. So I'm going to end up with his wife. But my wife was against it because we would have to feed her. So that ended that. The thing to remember here is that when you endorse an instrument and leave it in someone else's hands, it identifies a piece of property. They can use the property and the value of that property as collateral to acquire credit. There is no law against doing it. The law states that you can do it. One law states that you cannot steal. This law states that you can steal. This leads to confusion in law. Confusion in law is anarchy. What we have in this country is anarchy. There is no law here. Uniform Commercial Code 3-305 is titled "The Rights to Holder in Due Course." To the extent that a holder is a holder in due course, he takes the instrument free from all claims to it on the part of any person. Remember that this section is called the rights of the holder in due course. When one person takes the instrument free from all claims to it by another person means that if I bought the property, I do not have any right in the property because I do not even have a right to claim anything on it. Property is defined as the right to the use of a thing, not the thing itself. If you fill out anything, such as a voter registration that identifies you as a body, and leave that instrument in the hands of the government, they become the holder in due course of that instrument, not of your body itself, the instrument. They take the instrument free from all claims to it on the part of any person and acquire every bit of right in the property identified thereon, which is your body. We do not have any right in this country of property. Thomas Jefferson made a good comment. Without property, there is no liberty. We equate liberty with freedom, but that is not really an equation. Freedom is what we have in America. We have a lot of freedom. You are free to drive provided you pay the fee to get on the roads. You are free to work provided that you pay the fee to work, called income tax and Social Security. You are free to go fishing provided you have paid the fee for the license. The same is true for hunting and other freedoms that we have in America. But you are not at liberty to do anything because you do not have any property. Without property, there is no liberty. The police have told me that I could take my car home and start it up in the driveway and execute my right to travel all I want as long as I did not get off my property and come out onto their roads. Good point. On my property, in which I have possessionary interest, I have a right to travel. I can travel from one end of it to the other end of it. I cannot cross the line and go into someone else's property. That would be trespassing. If the state has deeded the land for the roadways to itself, then it is the state's private property. I need a permit called a driver's license to use their property, or I would be trespassing. This is another example of how we have been robbed in America. When you identify your property on this instrument that you are filling out, such as an application for registration of a car, and then it is signed by you and handed over to them. You have transferred the property to them, but you thought you were transferring it from the dealer to you because it says that on its face. If the state takes the paper and holds on to it in the middle of the transfer between me and you, the state becomes involved in the transfer and the state ends up with the right in the property. This is called fraudulent transfer. It is covered by statutes called fraudulent conveyance statutes. This is defined in the law dictionary as a conveyance or transfer of property, the object of which is to defraud a creditor or hinder him, or to delay him, or to put such property beyond his reach. A creditor is one who puts up the value for somebody else. It was your car. If you were selling it to me, you were putting the value of your car up to transfer it to me. I am the debtor. I am going to owe you for the car. The state gets into the middle of this transaction and hinders you from being able to get the full value of your car as a creditor. This is called unlawful conversion. An unlawful conversion is what occurs during an unlawful conveyance. Look up these words. A conversion is an unauthorized assumption or exercise of the right of ownership over goods or personal chattel belonging to another. What is the state doing with these instruments? They are perpetrating an unauthorized assumption or exercise of the right of ownership of these automobiles. The state is receiving the right in the property. If they are taking the right of the property, that is the part of the right of the ownership. Then they are exercising control over your use of the property that you think is totally yours and have the right in. This system is all fraud. Fraud everywhere. This system is designed to specifically get the value of every bit of your property away from you. All of this can be used as evidence, but it must be explained exactly what the fraud is. This is where we could use some help from lawyers that want to help the cause of liberty. It may require a retired lawyer with nothing to lose to help in this. There are a couple of court cases that I know of that expose fraud. One is U.S. versus Heron, 825 F2D50 from 1987. This case is about a man who made a lot of money and took it out of the U.S. and brought it back in small quantities so that he would not have to pay income tax on the whole amount. He perpetrated a fraud by doing this. This case is an example of what the government calls fraud. It is about hiding truth. This guy would not have had to do this had he known about the status of being non-resident alien. His money was made from non-government sources, from private sources, so he did not owe a tax anyway, but he did not know that. This case shows that what he did was a fraud because he was trying to hide it. Hiding the truth or right of property is fraud. In order to catch him, the IRS perpetrated another fraud themselves. The second case is McNally versus U.S. 483 U.S. Code 350. This also shows fraud and explains it in detail. This case details tangible and intangible property rights, along with tangible and intangible property right frauds. It shows what a fraud against a tangible property right would be. These cases should be put on your reading list so that you will be able to completely explain fraud and then make a case that shows the fraud in any area that you might need to apply. Fraud is everywhere, and you should practice describing it. If you begin to put these cases together properly, the government will back off where they would have come forward previously to this knowledge. I'm going to pause it there for today because my throat's starting to go again. But I do want to finish this book with you guys. I want to get it out there. So I am on page 37, at the bottom of page 37 of the PDF document, and the top of page 23 of the book. You guys see the difference? Here and here. And this is where we will pick up tomorrow on trespass and injury. Awesome. Okay. Any questions about what we've read today? Oh yeah, it's all a racket, Pappy. But we're trying to share this information to help people that don't understand or can't understand or aren't finding the information or are being confused in all the legalese or saying that or wanting to go the common law route. There is a way to get your sovereignty back, to get back out of their system. And that's what we want to help. We want to help people do this, to stand on their own 2 feet, but not to get wrapped up in another section of the law. And so, the whole point in this, whether it's appreciated or not, is to get this information out there. So hopefully this helps some of you. Hopefully you guys have gone and gotten a copy of the PDF and have read through it yourselves. The description box contains the links for SPC University, the downloads page, which is the area in which you will find this PDF. It's called Paper Arrows by Harold Griswold. So it's going to take a lot of work. You're right. And hopefully, this helps people. Well, don't fault yourself. We as a species need to stop looking for places to place blame. Okay. We already know it's easier to be conned than to admit that we have been conned. So let's take that upon ourselves. Okay, we've been conned. Don't beat yourself up for it.
Let's move forward.
Go forward. Say, what can I do to fix this?
Yep.
Right? Search for an answer in a positive way, and it negates a lot of the negativity. It'll just knock that negative stuff right out. So instead of beating yourself up about being fooled, recognize that everyone has been fooled.
Millions.
All of us, for generations, from the very get-go. The entire premise of our country is a lie. Okay? So if you guys have this one, wonderful. If you want another thing to read through that might be a little bit easier reading than the case law stuff, I know that gets confusing. That's why we decided to read it out loud, so that hopefully it would make a little bit more sense. It's hard to read about case law and legalese. But I implore you to find The Matrix and the, what is it? What's this called? The Matrix and, where are we at? Page 28?
Yeah.
Okay. How? Where?
Just it's over on the side. There it is.
Oh, yeah. Okay, hold on. The Matrix and the U.S. Constitution. That also is in PDF form. I implore you to, and it's listed under Judge, Judge Dale. It's listed as a Judge Dale article under the Gurus tab of that download page, okay? And it's called The Matrix and the U.S. Constitution. It is a lot easier to read and understand. So I want you guys to look that up and maybe read through a little bit of that. That's going to help you, give you a good solid foundation of what our actual history is regarding the legal system, the Constitution, and your so-called rights. Remember, if you are receiving benefits, you have traded something for that, okay? The book that we are reading from today is called Paper Arrows, and it is by Harold Griswold. What page were we on?
37.
Awesome, because I forgot that quick. And I wanted to mark it.
Okay, that's fine. We can go back now.
We'll begin with trespass. I already said that. Okay, all right.
Yep.
So back
yes.
over to the comments, please, for me. Yeah, so that is the name, Paper Arrows by Harold Griswold. It is under the Gurus tab in the SPC University downloads link that we have shared in the description box. The other one, I really think you guys, if this is difficult to comprehend because of the case law and the legalese in it, I understand that. If I didn't have prior knowledge of some of these things, it would be hard for me to comprehend as well. But I have had some experiences reading case law and finding things like that about legal definitions and things before. So I do have a basic understanding. But the Matrix and the U.S. Constitution is a very good read. It is written by Harold Griswold. I've actually, if you look in the description box, Anna, I have a link straight to the PDF of the book that we are reading. Okay. And we are down on page 37, you said? 37. And that is, we read to the end of 37. All right. So, use these tools, guys. Look around. If you find something that interests you more, or do you think that the public is going to be able to understand better, please let me know, and I will go to that material, because I have not by any means exhausted everything in that library yet. We've only just begun.
Just peeling the first layer out.
But when we come across things that I feel are important, some of you are going to understand, or that needs to be put out there for other people to have access to, I'm going to do that, even if it's not popular, just because it needs to be done.
You need to know, too.
These are things you need to know. Instead of exchanging your debt slavery from one system to another, if you're looking for real liberty, there's a way to go about it, and we'll help you muddle through it as we muddle through it. Okay. So having said that, much love and light, many blessings to you all, and we will see you tomorrow. And I will read more tomorrow. So thank you so much for being here, and thanks so much for giving us your ear.